Distinguished leaders, colleagues, and participants gathered today. I wish I could have been with you in person. Something important has come up at the last minute which requires me to travel. Even so, I'll try to do justice to this address by offering you the insights I had intended to share on stage. In my address to you today, I will focus on AI and technology as catalysts of legal transformation and the cultural shift we need to adopt on this technological journey. In pursuit of this digital discipline, I would like to offer for your consideration a code comprising 4 pillars and 4 objectives that enumerate my thoughts and that I believe will endure the test of time. Firstly, the 4 pillars. These are data, compute, trust and talent. To us, gainfully utilizing these pillars under conditions of accountability and robust governance are at the heart of the growth of the legal services economy in future. Flowing from these 4 pillars are 4 objectives: legal design, organizational thinking, imbibing digital professional norms, and trust in the built systems. These objectives are going to be crucial to scale safely, efficiently, and develop client-centric models. We at SAM are mindful of rethinking what tomorrow looks like for business operating at the speed of light and how the legal industry will have to step ahead in our creative legal advisory, transactional space, and dispute resolution. At the heart of it, design thinking is putting client at the center of the service while also enabling our lawyers with the right trustworthy tools to innovate. Measures that are in lockstep with this code are already underway at SAM, where our acceptable AI use policy codifies our philosophy. As I see it, we need to carry the torch of embodying legal principles into software and hardware architectures as a legal community built on principles of trust. This brings me to the 4 pillars of my code. First, data. We all know AI unlocks value from institutional knowledge database at unprecedented speeds. Firms must ensure robust governance. As AI models learn from the firm inputs, we must set policies that protect privacy and confidentiality and define usage boundaries. Second is compute, which refers to the powerful computational resources required for artificial intelligence to process data, train models, and perform tasks. The legal profession must rethink data strategies and adopt flexible, service-based technology models to stay current while upholding ethical standards in a rapidly evolving digital landscape. Third, talent. We must upskill every lawyer to work as an AI orchestrator, which is to say, lawyers must know how to use AI responsibly with prompt design and engineering to imbibe efficiency in their day-to-day work. Fourth, trust. We must empower laws for the delivery of their services to enhance principles of trust and truth. We must restate our doctrine of solemn trust owed to our clients and the community we serve. Consequently, flowing from the 4 pillars of change, 4 objectives become material. First, there must be an organizational rethinking of AI and law. What comes next is an organizational upgrade by design, placing importance on privacy and confidentiality, ethical safeguards, and risk awareness, right from procurement, training, data governance, and auditing of AI use. Secondly, practitioners must become legal designers and engineers. In the age of AI, lawyers evolve into multidisciplinary legal engineers who co-design, manage, and oversee AI-enabled legal infrastructures, embedding governance into AI systems. It is important to build domain-specific standards and safety tests, separating legal risk from domain risk, and instituting rigorous review to curb hallucinations and bias before output reaches clients or courts. Third, firms must imbibe digital professional norms, disclosing AI use to clients, honoring their preference, and retaining standards of confidentiality are going to be important. Institutionalizing second person review of all AI outputs to prevent hallucinations and keeping development of talent at the center of legal profession are going to be the order of the day. Fourthly, creating a new trust in our built systems. We must restate our fundamental principles of trust in our infrastructure, architecture, and software, and commit to an error-free environment in which we generate and embed a freer environment devoid of any distortion like hallucinations. At SAM, this future is already in motion. Since ruling out Harvey in April 2025, 75% our lawyers use it. These gains are most visible where pattern-based workflows were automated, such as contract drafting and redrafting, knowledge management, and dispute resolution support, freeing our teams to focus on complex analysis and strategy. At SAM, maintaining firm level and team level prompt libraries tailored to practice needs, improving accuracy and reuse are being put in place. We are understanding the need for an encyclopedia of the right question or prompts. We located Harvey servers in India to strengthen client confidentiality, privacy, and compliance. In conclusion, the legal profession stands at an inflection point and will continue to change. I am hopeful that in building successful and technological resilient practice, my code and its objectives shall serve as a valuable guide. While the goal of lawyers is to serve justice for their client, we have to realign ourselves to create a digitally equitable society that uses AI responsibly and trustfully. I thank you all and this August forum for inviting my thoughts, my appreciation to Oak Bridge Publishing for curating this conference with such purpose, wishing you all the very best as you continue to shape this dialogue.